Hello again. This is the second video in the series Know Your Rights. And please remember that nothing that is said in these videos constitutes legal advice. If you need legal advice, you can always contact me in my capacity as a barrister, but nothing in the videos constitutes legal advice. Now, in this second video, I want to just sketch out the basics of the legal system in this country, this jurisdiction. First of all, let's just clarify what we mean by jurisdiction. A jurisdiction is an area where a particular set of laws or legal system is in force. Now, this country, the United Kingdom, is made up of 3 different jurisdictions. There is the jurisdiction of England and Wales. That is combined. England and Wales is one jurisdiction. Scotland is a second, and then thirdly, Northern Ireland. There are 3 jurisdictions in this country. The Republic of Ireland is yet a separate jurisdiction, but not part of this country, of course. In the United States, every state is a separate jurisdiction. So there are 50 states, 50 jurisdictions, and federal jurisdiction, that's an extra one, and also the District of Columbia, Washington, D.C. is yet another. So that is the way jurisdictions work. So 3 jurisdictions in this country. What that means is that if a case arises in one of those jurisdictions, it has to be dealt with in that jurisdiction normally. Otherwise, there's got to be extradition and various other things. But each jurisdiction is separate. Now, within the jurisdiction of England and Wales, which is the only one I'm going to be talking about, the law courts are divided into 2 main sections: civil law courts and criminal law courts. Now, a civil case is one which is between an individual and another individual, or a business and another business, or an individual and a business, or between an individual and the government. Quite a lot of cases involve the government. But all those cases are civil cases which are to be distinguished from criminal cases. Now, a criminal case is a case brought by the state, or in this jurisdiction called the Crown. It's always brought in the name of the Crown, the Queen, for an alleged breach of the criminal law. And that means a law affecting the public at large. The obvious ones are murder, robbery, rape, and so on, fraud, although fraud can also be civil. So there's a big difference between the 2 types of law and the way they are handled. Criminal cases all begin in the magistrate's court. Yes, even a murder trial will begin in the magistrate's court and will then be transferred to the Crown Court. All more serious cases go to the Crown Court, and cases which are what are called triable either way can be tried either in the magistrates or in the Crown Court, and that is a matter of choice for the defendant or the accused. It's the same thing. The accused and the terms accused and defendant mean the same. And the accused or the defendant can choose, in those cases, triable either way, the sort of intermediate cases, whether to go to the Crown Court or the Magistrates' Court. Now, in the Magistrates' Court, the court is made up of a bench of magistrates, usually 3, who are lay people, or one lawyer who is referred to as a district judge, previously known as a stipendiary magistrate, or a stipe, which actually was a much nicer title, I think. So in the Magistrates' Court, there is either, the trial is conducted either by a stipe, or district judge, that is, or by a bench, usually of 3 lay magistrates. In the Crown Court, there's a jury, and that's the big difference. It's trial by jury, judge and jury. There's a judge sitting with a jury, and the jury has to decide on guilt or innocence. So that's the criminal side of the courts. Civil courts are more complicated. For very, very low value claims in court, civil claims such as someone owing you money up to £10,000, that's a small claim that goes to the small claims court, which is part of the county court. And most cases these days go to the county court. And only very, very high value or very complex cases tend nowadays to go to the high court. So the hierarchy of civil courts is county court, the lowest, then the high court, then the Court of Appeal, civil division. There's also a Court of Appeal on the criminal side, which is called Court of Appeal Criminal Division, but Court of Appeal Civil Division, and then the highest court of all, which is now called the UK Supreme Court. That took the place a few years ago of the House of Lords sitting as a court. It wasn't the same body as the House of Lords as a parliament, but only a few members of that. That was a very, very ancient system going back very many hundreds of years. But that was changed a few years ago so that now the top court is called the UK Supreme Court, which is not exactly a particularly original title for it. But that is the very top court. Now, what about the European courts? Well, as Britain is now essentially out of the European Union, the Court of the European Union, which is called the European Court of Justice, ECJ, is no longer plays a role in this country. That court is the court of the European Union. The European Union court, which sits in Luxembourg. But there is another European court which still has effect in this country, and that may surprise some people. It still is very, very active in regard to this country, and that is called the European Court of Human Rights, which sits in Strasbourg. That's confusing because Strasbourg is also the seat of the European Parliament, or one of the 2 seats of the European Parliament. because the European Parliament alternates between Strasbourg and Brussels. But this court, the European Court of Human Rights, has nothing whatsoever to do with the European Union. Nothing. Nothing. It seems strange that it should be there in Strasbourg, and it actually predates the European Union, but it has nothing to do with it at all. It's got more members than the European Union has. It's got about 47 members. It has nothing to do with that. It's a human rights court, but it is not a court to which you can go directly. Any human rights case can now be heard by any English court, by any domestic court, we say, by any court in this jurisdiction. Human rights cases can all be brought, or any case which has a human rights element to it, can all be brought in this jurisdiction, and should be brought in this jurisdiction initially. And that is all governed by what is called the Human Rights Act. Human Rights Act, which incorporates the European Convention on Human Rights. And that convention is right there in the Human Rights Act. And it's only if you cannot get satisfaction from any domestic court that you can go to the Strasbourg Court, the European Court of Human Rights. But the European Convention on Human Rights is applicable inside the United Kingdom as well. It's actually applicable throughout the United Kingdom, not just in England and Wales, but also in the other jurisdictions. So I hope that's not too confusing, so that when people talk about going to the European Court, if that means the European Court of Human Rights, that is still possible. That is still possible. I think that's all I have to say in this second video, and we'll pick up a different theme next time.